both the Code of my attorney for ineffective assistance of counsel. Reporting misconduct is mandatory in both the Code of Judicial Conduct as well as the Rules of Professional Conduct. The state's attorney should as well then, Your Honor. You took an oath of public service and violation of that oath is treason. Not to cite my attorney and the state's attorney for violating the rules of professional conduct is a violation of that oath. In judicial conduct, you are also legally obligated and required by the Code of Conduct to do so. My attorney and the state's attorney are therefore required to cite you for judicial misconduct upon failure to do so. Informed consent is required before these proceedings can go forward. It is required I have reasonable knowledge to give informed consent, and that reasonable knowledge would be informing me exactly what due process is, and that's explained in the Rules of Professional Conduct and the Code of Judicial Conduct. A fair trial would require everyone in a court of law make sure that I have reasonable knowledge to give informed consent. Now, effective assistance of counsel is a double-edged sword and cuts every way you swing. Every attorney is required to abide by and enforce the rules. My attorney for ineffective assistance. My attorney for ineffective assistance of counsel.
Okay, Juan gave you.
Okay, people, let's talk about reporting misconduct.
Juan gave you the short
Rule
version.
8.3. Reporting professional misconduct and
Juan gave you the short version. I got a long version that's kind of put that one to sleep. All right, so I got to scroll down.
authority. B. A lawyer?
Regulations or constitutional rights.
Okay.
The rules of
As you
professional
can see, I
conduct.
talk a lot.
Conduct. Reporting misconduct plus 6 under the
Basic obligation of public
U.S.
You
Constitution.
should really get on
service.
that.
The foundation for ethical behavior. Executive
Talk
Order
to all your
12,000.
politicians about
No
that. You heard them
individual
town
entity
halls.
can completely erase a person's fundamental rights, but the government can legally restrict or temporarily.
And I've explaining for years. Okay, not to get off.
The power to strike down these laws is known as judicial review, a doctrine firmly established by the Supreme Court in the landmark 1803 case Marbury v. Madison.
Rights refers to the unlawful taking away of.
What is it called when a judge and lawyers work together and violate the rules of professional conduct and the Code of Judicial Conduct to deny a fair trial plus 1-4 when a judge and lawyers work.
Yeah, that's what you're dealing with. That's what we're all dealing with in court,
Malicious
y'all.
prosecution can pursue civil tort claims to recover compensation for their losses. Damages typically fall into 3 categories.
Forget that what you're rebelling against is a homicidal, genocidal, pedophilic collection of war profiteering sociopaths.
Okay, I asked the
The systematic and
of office for.
It might not happen today.
Not in competition with anyone else.
Talk about ratifying the 13th Amendment. Talk about the puffery, the legal definition. The law of puffery refers.
I'm here to show out. Did not come here to impress you. Because to tell you the truth, when I leave here, I'm called. And I don't care what.
Ineffective assistance of counsel and
Okay, I got a young
deprivation
guy
of
trying
rights
to
under the
overturn
color of law.
wrongful conviction.
Information is
I
false
just
or
wanted to
inaccurate. Rule 8.
I'm almost there.
clean.
That triggers enhanced criminal penalties and immediate
Potential not yet reached. Goals not yet achieved. Dreams.
A lot of stuff you should know about. Remember, ignorance of the law is no excuse in a court of law. They'll use it against you all the time. Been used against me on numerous occasions. Never worked, though.
Alright, I already.
Giving illegal orders, particularly in a civilian context involving law enforcement.
It's illegal. Unlawful orders, illegal, unconstitutional, anti-rule of law. Always said the rule of law was just an illusion. Okay, here we go. All right, this is a post, a combination of quite a few laws that make it make sense. Don't blame me that nobody lives up to the oath or any job descriptions required by the oath. Violation of the oath alone is deprivation of rights. Nobody being prosecuted for violating the oath clearly shows a conspiracy against rights under the color of law. Look it up. It's on the net. Okay, let's hit that link there. That takes you to my page. Now, forgive me if I get a little emotional. I worry about you. And I worry about what you're going through. So let me tell you what you're going through. I went through it. We all go through it. This is a daily occurrence in every court, everywhere. Okay. Ignorance of the law is not a valid defense. Holding me to a higher standard than you hold yourself, the malice in law, the presumption of guilt prevails. The plea was made, that's if you made a plea deal, the proceedings thus far were under duress due to disinformation, lack of disclosure, the lack of informed consent. Informed consent requires reasonable knowledge to make an informed decision to give informed consent. It would have been competent, I'm using the rules of professional conduct to get them to act on it. It would have been competent, Rule 1.1, diligent and candid to communicate, to advise, to be fair, and to show impartiality and decorum with truthfulness, and divulge the rules of professional conduct and the code of judicial conduct, the legal obligations of all lawyers and judges to maintain the requirements of disclosure. That's deprivation of his rights, as reporting misconduct is mandatory in both the rules of professional conduct, the code of judicial conduct, and no one, not counsel for the defense, the opposing party, nor the judge reported each other or themselves for misconduct, which is misconduct. What should have happened at the very beginning didn't. The rules of professional conduct, code of judicial conduct, that tells you everything that's supposed to happen from the very start. What should have happened at the very start didn't, creating a conspiracy against rights under the color of law. In the public interest, that's a law. In the interest of justice, that's a law. Justice must be served, that's a law. Your oath requires it. It does. This is all the stuff they're supposed to do behind the oath. First and foremost, holding a layman, pro se litigants, to legal requirements, the expertise of a legal learned professional refutes the very principle of a fair trial, clearly in the interest of the bar, against the law, not in the public interest, against the law, thus under the color of law, against the law. That's highly unethical, against the law. You can file ethics complaints, and violates the rule of law. This shows bias holding a layman to the standards you have yet to hold yourself or others in the legal profession, and clearly shows a conspiracy against rights under the color of law. Or added to my motion, or add to it, my motion is denied. Statute of limitations cannot apply to those who lack the reasonable knowledge, legal knowledge, to make an informed decision to give informed consent. The lack of disclosure from the very beginning created this constitutional crisis, which suggests the court's effectiveness was limited, and why. I reiterate, in the public interest, in the interest of justice, justice must be served. Your oath requires it. Conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counsel for ineffective assistance of counsel, and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. Failure to report misconduct is misconduct, as is a failure to enforce one's constitutional duties as prescribed in the rules and the codes. The lack of the requirements of the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist. A deprivation of rights in its entirety It clearly shows the judge and attorneys in my case committed a conspiracy against rights under the color of law. 18 U.S.C. 242 prohibits the willful deprivation of rights, privileges, or immunities under the color of law. Qualified immunity does not apply because they did this to you. Prohibits conspiracies to injure, oppress, threaten, or intimidate any person in the free exercise, enjoyment of any right or privilege secured by the Constitution or laws of the United States. I trust you will live up to the oath and show competence, diligence in expediting litigation, as I have meritorious claims and contention. So I strongly stress reporting professional misconduct and maintaining the integrity of the profession. I trust communications will be made for ethical violation. Every penalty will be imposed in the public interest as trustees. This is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. An interest of justice dismissal with prejudice is legally required, as is inciting the RICO Act. Okay, people, so let's fill out some forms. Forms to fill out. Ineffective assistance of counsel motion. IAC motion. Motion to quash. Writ of habeas corpus. Writ of certiorari. Rules of professional conduct complaint form. Code of judicial complaint form. Deprivation of rights complaint form. A conspiracy against rights complaint form. Ethics complaints form. Post-conviction complaint form. Whistleblower complaint form. And you could also file a late notice of appeal. Like I said, the statute of limitations doesn't apply to you if it doesn't apply. They're not abiding by anything that I just spoke of. You know, look at this knucklehead. Americans must stop personal attacks on judges. He says it's got to stop. He says criticizing court decisions is fine, but going after judges themselves is dangerous. Well, you put yourself in that hole, you big jerk. The rule of law is endangered. Well, you know what? Penalties for violating the rule of law. Penalties for violating the rule of law depend on the offense severity, ranging from fines, community service, and probation to imprisonment, loss of professional licenses, or forfeiture of public service. These legal consequences are forced through criminal imprisonment, fines, or civil damages, court orders, systems to upload social order, key types of penalties, criminal penalties, imprisonment, heavy fines, restitution to victims. I mean, what public servant isn't violating the letter of the law? It finds restitution to the victims, in extreme cases, the death penalty. Civil penalties, substantial monetary fines, often daily injunctions and penalties designed to deter misconduct, frequently applied to corporate or administrative breaches. Professional official penalties. Public officials may forfeiture of office, retirement benefits, and disqualification from future service. Contempt of court. And not doing any of this is contempt of court. Everybody gets cited for contempt of court. You know, you'd be like Oprah. You get contempt of court, you get contempt of court, and you get contempt of court. And to add to the bonus, you get charged with deprivation of rights. You get charged with deprivation of rights. Everybody gets charged with deprivation of rights. And since nobody reported his misconduct, everybody gets charged with a conspiracy against rights under the color of law. Impose fine, settlement up to per day, failing to follow regulations, legal protections, the fair severity of penalties, and other proportional but aggravated circumstances such as injury to the use of weapons significantly escalates consequences. Violating the rule of law, people. Did you understand that? Penalties for violating the rule of law. Penalties for violating the oath of office in the U.S. include removal from office, criminal prosecution, imprisonment, fines, and disqualification from future office. For federal officials, 18 U.S.C. 1918 specifically mandates removal and potential fines or imprisonment for violating the oath, while presidents face removal through the constitutional impeachment process. violating the letter of the law. The strict literal interpretation of statutes can result in penalties ranging from civil fines and license revocations to imprisonment, depending on the severity of the offense. Penalties often enhance or willful misconduct compared to unintentional negligence. Penalties for disinformation. Lawyers face severe consequences for disinformation, including hefty fines, financial penalties, ethics board disbarment, and case dismissals. So anything they ever worked on, all their cases get squashed. Judges involved in spreading intentional falsehoods face judicial counsel removal or impeachment, as the law specifically treats misrepresentation by court officers and as an abuse of the justice system. So remember, there's penalties for disinformation, violating the letter of law. Anything they say devoid the letter of the law, violating the letter of the law has penalties. But when they do it, that's disinformation, and there's penalties for that. So even though they're quite similar or the same, they get charged separately for each one. Okay, so that's just...
Okay, Pearson versus Ray 1967 is a landmark Supreme Court decision. This is very important to you. It's important. It was important to me when I first read about it. It should be important to you.
How they started.
Established a doctrine of qualified immunity for police officers, allowing them to avoid financial liability in civil rights lawsuits if they acted in good faith and with probable cause when making an arrest. Okay, for a quick background on the landmark case originated and the specifics of the court ruling, the background: in September 1961, a group of 15 white and black Pentecostal clergymen, including Reverend Robert L. Pearson, attempted to use segregated facilities at a Jackson, Mississippi bus terminal. Okay, Police Captain J.L. Ray ordered them to leave. When they refused, he arrested all 15 for breach of peace under a Mississippi state law. The ministers found guilty, jailed, and fined. However, the statutes that they were charged under was later declared unconstitutional in an unrelated case. They were ordered to separate because they were race mixing, and the sign on the wall said, coloreds only. So the police thought this was law. So that's why everybody got arrested. Ministers were found guilty and fined. However, the state statute they were charged under was later declared unconstitutional in an unrelated case, because any laws repugnant to the United States Constitution are void. So the Jim Crow laws were unconstitutional. Okay, they were anti-rule of law. Okay, so the Jim Crow were anti-rule of law, so it's ridiculous. Okay,
that's enough of that. I'm gonna let you go for now, but
The Dixiecrats were a short-lived, far-right segregationist political party that splintered from the Democratic Party in 1948. Officially known as the States' Rights Democratic Party, they opposed federal...
They were known as the Conservative Party. All right, y'all, you have a good night. Nothing but peace and love.
In the lawsuit following the dismissal of their conviction.
This is where I'm at on my page, Legal Reform, on Facebook. So if you want to find that, what I just read to you, you're going to have to look. It's here, the wording. It's too long to put in any comments on the other, anywhere. But I think you'll like using the long version and the short versus the short version that Juan Cortez gave you, but even the short version is quite effective. Okay. I just wanted to go. Whoa. This is what we need. We need leaders not in love with money, but in love with justice. Not in love with publicity, but in love with humanity. If you read the basic obligations of public service, you'll understand that a whole lot better. So people, when you're out there and you're electing your future leaders, look for those that are from the people, of the people, and for the people. People like yourself. You know, seriously, quit voting for these rich people because they're just looking out for their special interests. And if you look up the basic obligations of public service, you'll find that, you know, there's a lot of things being done that shouldn't be done, like all this money in politics. That's what I've been doing. Telling my story. Telling my stories. Things I've been doing for years. That's law, people. All right, I want to wish you good night, all right? I'm tired. I haven't slept much in the last couple of days. A little ill. Lost about 20 pounds, but as long as I don't lose anymore, I'll be okay. I want to wish you good night. May your Creator always be with you and rain many blessings. I wish you a long life and good health. Always a long life and good health. Something I was deprived of, but I desperately want for you. And if we work together, we can do this. All right? Peace and love, people. I want nothing but joy and happiness in your life. Joy and happiness. Good night.